If you're like many Californians, your house is your main asset, and it's one you would like to leave to family members or other beneficiaries. A revocable transfer on death deed is one of several ways to transfer your home to others upon your death. What's the purpose of a transfer on death deed? It's meant to be an inexpensive way to pass your California home to others when you die. Now, if you own your house with another person, your deed already may reference a right of survivorship. If that's the case, the property will pass to the surviving owner, and there may be no need for a transfer on death deed. If you are the sole owner of your home, you can create a last will and testament to designate who will receive it when you die. But in most cases, your home will need to pass through the probate process in the Superior Court, which may take a year or more and will carry costs that depend on the value of your assets. Many folks who own homes choose to create a revocable living trust. If you have such a trust, your house and other assets will go when you die to the beneficiaries you name in the trust document without going through probate. Also, a trust allows your assets to be managed for you if you become incapacitated. A transfer on death deed, though less flexible than a trust, also allows avoidance of the probate process. How does a transfer on death deed work? The homeowner must sign a special form of deed. California Probate Code, Section 5642, includes the form of the deed along with frequently asked questions about how the deeds work. You may obtain forms at your local county public law library or visit the website of the Sacramento County Public Law Library. You will need the legal description of your property. You can find the legal description on the deed you received when you bought or received the property. You will need your assessor's parcel number. You will need the full names of your beneficiaries. They may be individuals, such as your children, or they may be an entity like a charity. Your beneficiaries will receive the property in equal shares. For example, if you name your son and your daughter as the only beneficiaries, they each will receive a half interest in the property when you die. But if your beneficiary dies before you do, that person's share terminates, and the other beneficiaries will receive larger shares. Going back to our example, if your son dies and then you die, your daughter will receive a full interest in the property, and any children of your son will not get any interest in the property. Your beneficiaries will not have any ownership interest in the house until you die and the deed takes effect. What's the process for completing a revocable transfer on death deed? This type of deed must be notarized, witnessed, and recorded. Let's break that down. After you have filled in the document, you will need to sign it before a notary public, who is a person authorized to certify your signature. You may find them at title companies, banks, and mailing services. You also need two other witnesses. They should not be the persons named as beneficiaries in the deed. Your witnesses must be present together when they sign. Once the deed is notarized and witnessed, you must record it with the county recorder. You must do this within 60 days of notarization, otherwise the deed will be invalid. You don't have to give a copy of the deed to any of your beneficiaries, but it may be helpful to them if they have it. If property co-owners want to use a transfer on death deed, they must each sign and record a separate one. Of course, don't sign a transfer on death deed unless you freely choose to do so. You should not be pressured into signing a deed or any other document. What do your beneficiaries need to do when you die? Your beneficiaries will need to follow steps to obtain title to the home. They will need to record an affidavit of death and file a change in ownership notice. They will need to provide a written notice of the deed to your heirs at law, also known as your next of kin, and record an affidavit confirming that the heirs were given written notice. If you received Medi-Cal benefits, your beneficiaries will need to notify the State Department of Healthcare Services of your death. Will creditors be able to make claims against your beneficiaries? Yes. The house will be subject to any mortgage recorded against it, so your beneficiaries will need to deal with the lender. If you have debts other than a mortgage when you die, your creditors may try to collect their debts from the beneficiaries who receive your house. How do you revoke a transfer on death deed? You automatically revoke the deed when you sell or transfer the property. You may record a new revocable transfer on death deed and it will replace the older one. Otherwise, you can prepare a revocation form. Revocations need to be notarized and recorded to be effective. To summarize, a transfer on death deed may help your beneficiaries avoid the expense and delay of the probate process with respect to your home. But there are rules that you must follow carefully to create a valid deed. Your beneficiaries, after you die, also must take steps to receive title to the property. You can find the rules relating to transfer on death deeds at California Probate Code sections 5600 to 5698, which you can look up on the internet. You should plan ahead if you are interested in creating a transfer on death deed. An attorney licensed by the State Bar of California can advise you about your options, including how to create a valid deed.